The division bench, in the facts of the said case, held that the appellant, who was a complainant, was not a victim who was entitled to prefer an appeal under Section 372 of the Code, and, therefore, she could not prefer an appeal under Section 372 of the Code in the police case. According to the division bench, even otherwise, if the appellant was supposed to be covered by the definition of victim under Section 2 of the Code, having a right to prefer an appeal against the order of acquittal, according to the division bench, she was required to file an application for grant of leave to appeal. The division bench further pointed out that even against an order of acquittal passed in a case instituted upon a complaint, the complainant has been provided the right to appeal, and he can file such appeal with an application for grant of special leave to appeal from the order of acquittal. Thus, under the Code, the division bench proceeded, the appeal against acquittal could have been preferred only with the permission of the High Court on an application filed for grant of leave to appeal against the order in appeal. According to the division bench of the said High Court, the proviso to Section 372 of the Code gives a right upon the victim to prefer an appeal against the order of acquittal being sufferer from the act or omission of the offender, but such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. The division bench further held that by the proviso, a right to file an appeal has been conferred on the victim against the order of acquittal, but the procedure for filing such appeal will be the same as provided under Section 378 of the Code. Under Section 3 within bracket 1, it has to be established that there was some casual connection between the death of the workman and his employment. If the workman dies as natural result of the disease which he was suffering, or while suffering from a particular disease he dies of that disease as a result of wear and tear of the employment, no liability would be fixed upon the employer. But if the employment is a contributory cause or has accelerated the death, or if the death was due not only to the disease but also the disease coupled with the employment, then it can be said that the death arose out of the employment and the employer would be liable. On the strength of Jyoti Adama's case within bracket, supra, learned counsel would submit that there is no iota of evidence that the deceased was suffering from any heart ailment and that his employment as driver contributed to or accelerated the death. Admittedly, deceased was employed as driver with the appellant. It is the specific case of the claimant that due to excessive work load driving, deceased suffered severe heart attack which resulted into his death. It is also the specific case of the claimant that the death has occurred during and in the course of employment. On the other hand, it is the case of appellant that deceased has not died during the course of employment, and in the present case there is no connection between the death and employment of the deceased. Though the allegations made in the claim petition has been denied by the appellant employer, but a perusal of record would reveal that the pleadings and evidence has not been specifically controverted by the employer. In cross-examination, DW1 Vriksha Ram has admitted that it is possible to suffer heart attack due to excessive driving work taken by the employer.